back to the show. This is The Law Show on CL 650.
The winner takes it all.
Well played, Dwayne. I like that song. The winner takes it all. Well, you're listening to The Law Show on CL 650. We're talking about personal injury. Kevin Hyde is here from McQuarrie Hunter. He's a partner and associate. Nate Hartney is here. And McQuarrie Hunter has how many lawyers in your personal injury department?
We've currently 7 lawyers in our personal injury department.
All right. So when somebody's involved in an accident, I, as a layperson, I've heard this term statute of limitations. It means how long is this viable, right? What does that mean, and how long is it for an accident?
Yeah, what that means in most cases, most motor vehicle accidents, is that you have 2 years from the cause of action, which is the date of the motor vehicle accident, to start your claim. There are some exceptions to this, however. If you're a minor under the age of majority, which is 19 in British Columbia, that's when the limitation starts running. So if you're 15 years old at the time of the accident, the 2 years doesn't start running until you're 19 years old. So you have until you're 21 to file your notice of civil claim to start the litigation.
I guess that's to give you the right as an adult to make that decision for yourself.
Exactly.
Can a parent do that on behalf of a child?
You can always start the claim earlier in certain circumstances, and then any settlement that occurs of someone who's underage and can't sign the settlement agreement has to go by the public guardian and trustee for approval. Another example where there's less of a limitation period, a shorter limitation period, is when you're suing a city or a municipality. Under the Local Government Act, you have 6 months to actually start your claim. But something further to that is you actually have to give a notice that you might be filing a claim against the city and that there's been an injury or alleged negligence against the city within 2 months to give written notice of that.
I'll throw a fly in the ointment. Say you're in an accident with a city vehicle. Is it still ICBC in 2 years? Or is there a difference because it's a city vehicle? I wonder what that is. Or is this is just liability if you slip on city property?
This would be more a case of a slip and fall that you have to provide this notice to the city. In the motor vehicle case, I don't think
that will be 2 years.
That shortened notice period will apply.
All right. So there's been lots of advertising in the last 6 months around ICBC saying, a big part of our expense is paying false claims, and we're cracking down on fraudulent claims. Now, you see people who are coming to you because they've been injured. Are people faking it? Is this a trumped-up claim by ICBC?
My personal opinion is that the claim that fraud and exaggeration is widespread I just do not believe it. At McQuarrie Hunter, I've worked on cases for ICBC in the past. So I've seen that side of it, and I've also seen it from the other side. And I just don't believe that it's as widespread as some people think, and as I think some of those advertisements would lead people to believe. And I say that because, if you are going to pursue some scheme to defraud ICBC, your entire life is going to be looked at. All of your medical records, your employers are going to be talked to. Everything is going to be examined in such great detail that it just doesn't make sense that people would do that and not be uncovered, right?
Sane-minded person, at least.
Somebody who has been a hardworking person their entire life, honest, everybody who knows them can say what type of person they are. They're not just going to go and turn around and decide to defraud ICBC because they were involved in an accident. It just doesn't make sense. And yet, those types of people get accused of fraud and exaggeration and malingering, and it's unfortunate. And
you've experienced people coming into your office. Do people say, "Oh, well, my back hurts," but they may say it hurts a lot more than they really feel, hoping to get more money? But after, this is a long process, right? So
it is a long process.
And can you tell that when someone's coming in that somebody's exaggerating, and do you just say, "Listen, let's get to the core of what's really going on here"? Is that part of your job?
Well, I will say the majority of my clients are not exaggerating. Pain's obviously a very subjective thing, especially when it comes to soft tissue injuries. And pain for everyone is different. And, as Nate said, I'm not saying there isn't people out there who are exaggerating their injuries, who are claim aware. However, it's not as prevalent as ICBC is leading you to believe. And the vast majority of my clients, almost all of them are, I would say all of them, all the ones we've taken on, are people who are actually injured.
They don't want to go through this. No
fault of their own, and they're stressed out about this entire process of dealing with ICBC. And another advantage to retaining Macquarie Hunter is that once, or a lawyer is, once that you're retained, ICBC is not talking to you anymore directly, only with regards to maybe your Part 7 benefits, which we can help you with as well. But with regards to the tort claim and your injuries specifically, they're not talking to you. They have to go through the lawyer on every step of the way. So that takes a big stress off of people, and you can just concentrate on getting better and getting the proper treatment. I'm
guessing most people wouldn't wish an accident on anybody, and having to go through this, it's like, yeah, even it doesn't seem like people they just want to get back to their own life.
And you talk to their spouse, you talk to their friends, you talk to their coworkers. Are they really tricking all of these people? Right? I mean, keeping up this charade for years, it doesn't make any sense.
Even when we hand them that settlement check after we've settled their claim, I bet almost every one of my clients would say they'd rather go back and not have been in that accident, not been rear-ended, rather than have this check in hand right now.
So that's a pretty good answer.
And the other aspect to what you raised, Zach, about the costs of claims and how that's causing ICBC to have to raise their rates, it's not as simple as that, because accident rates have been going up. A lot of people think that's due to distracted driving and texting, as well as the cost of litigation has been going up. A case that ICBC could settle at the outset, instead of settling it, we have to prepare for trial. And we have 10 experts with reports. They have 10 experts with reports. And a case that settles before trial, there could be $100,000 in costs to the lawyers and the experts that wouldn't have been incurred if ICBC had settled it earlier. And that expense is then included in their cost of bodily injury claims. But that money never goes to the injured person. So that's another issue that people don't think about.
Now, there's the argument that they say the lawyers are ratcheting up the costs, right? But you're saying that ICBC could come with a fair settlement.
Sure, and there's other things that can be done. Like in Ontario, for example, there's a limit of 3 experts per side per case. So there's things that can be done in our litigation system that could try to control these costs. But it's not injured people making off like bandits that's causing the rates to go up.
So what I'm reading between the lines is, if ICBC came with their best offer to start with, their costs could eventually be less if you didn't have to bring more lawyers.
Absolutely.
in court.
They could assess the claim properly at an earlier stage, rather than taking all of them right to the eve of trial and putting these our plaintiffs, our clients, right to the eve of trial before they actually pay them a fair amount of money. And by that point, as Nate said, they've had to fully prepare for trial, serve expert reports, incur the costs of those experts, and so on, which often are unnecessarily done because they could have settled for that amount months before.
Now, one of the things I've heard is that, somebody might not seem to be in a bad accident, but they're affected dramatically, and they're not able to do what they were doing before. And that's kind of the real test. Are you able to do what you were able to do before the accident? And because it's a low impact collision, some people are greatly affected by that. But you actually have to build that case with experts who can testify that actually is the case, right?
Well, it doesn't really matter whether it was what ICBC classifies, and this is their own internal policy they had going on for several years, which has been discredited by science and medical experts and the courts, of low velocity impact collisions. Basically, they're saying if there's no damage to the vehicle, this wasn't a collision at any high speed, well, you can't possibly be injured. And that's absolutely incorrect.
So you have precedent for that in court?
Yes, of course. The judges have discredited ICBC for this completely. And what ICBC's done with these low-velocity impact collisions policy that they had in place was convince people that they weren't injured, or they were attempting to. Oh, you can't possibly be injured at that. Oh, well, if you took this to court, you wouldn't get any more money than we're offering you right now. And a part of the tactic was to keep them away from lawyers. But there's cases all the time where there could be a large accident where the airbags deploy, and I've been in one where I walked away with almost no injury at all. And then there could be my friend was hit at a very low speed, and this is someone I know well who's credible, and they've been injured for years as a result of this. They still have back issues and neck issues.
And there's that fine line between when the airbag doesn't go off and when it does go off. You know, it's hard enough that it injures you, but not hard enough that the airbag deploys. So some of those might be the worst, right?
It could be.
All right, we're going to take a break. We're going to get into, why would you need to go with a larger firm and sort of the misconceptions about personal injury lawyers and why you should speak to exactly who we have here, Kevin Hyde, a partner at McQuarrie Hunter, and Nate Hartney, an associate at McQuarrie Hunter, about if you're involved in an accident of any kind, you should speak to the people that know exactly how to stick handle their way through the system. We'll continue the conversation. This is The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.